Thank you, Mr President. I lead for the opposition in debate on the Community Protection Legislation Amendment Bill 2018. The opposition does not oppose the bill. The purpose of the bill is to amend some of the legislation dealing with the supervision and detention of high-risk offenders and to make a number of amendments to the Crimes Act and an amendment to the Crimes Appeal and Review Act. This is a grab bag of a number of unconnected issues compressed into one bill, again to deal with the logjam of legislation that this government has created at the end of its 8 years in office. Commencing with Schedule 2 of the bill, this consists of proposed amendments to the Crimes Act. A new offence is established by proposed new Section 25C, which has a heading of, quote, amendment concerning supply of drugs causing death, unquote. The bill explains that this provision makes it an offence to supply a prohibited drug for financial or material gain if the self-administration of the drug by someone else causes or substantially causes that other person's death. It is a requirement to prove that the person who engaged in this supply knew or ought reasonably to have known that the supply would expose a person to a significant risk of harm. The offence will be punishable by imprisonment for 20 years as a maximum. The elements are obvious. There must be a gain to a supplier. The supplier must have or ought to have had a particular sort of knowledge, and it applies to prohibited drugs. Proposed new Section 25C(4) provides that prosecutions can be instituted only with the approval of the Director of Public Prosecutions, a mechanism clearly designed as an extra precaution which is appropriate with a quite novel offence that may have unintended consequences. Proposed new subsection 5 states that Section 18 of the Crimes Act does not apply to an offence under Section 25C. Section 18 is headed, quote, murder and manslaughter defined, unquote. The opposition does not oppose the bill, and we are persuaded that there may be a gap in the law where quite serious criminal behaviour is not murder, manslaughter or a conspiracy, yet nevertheless should be rendered criminal, and that this provision is aimed at doing that. The opposition received representations from the New South Wales Bar Association recommending opposition to this aspect of the bill. Given the seriousness of the issue, it is appropriate for the opposition to place the Bar Association's concerns on the record of the Parliament, and the government is asked to respond to the Association's concerns. The Association's briefing note states, and I quote, the New South Wales Bar Association strongly opposes the proposed amendment for the following reasons. The first reason is that the proposed provision breaches a fundamental principle of the criminal law in this country and around the common law world, that an accused person should only be held criminally responsible for events that the accused caused, unquote. The note also states, and I quote further, so far as the Bar Association is aware, it has never been the law in this country or in other common law countries that a person can be made criminally responsible for a homicide where no such causal relationship can be established. This is because, for all offences involving prohibited results, it is a fundamental principle that a causal relationship between the actions of the accused and the occurrence of the event must be established, unquote. I note also the Association's reference to Royal, R-O-Y-A-L-L, versus the Queen, and Burns versus the Queen. The briefing note quotes High Court authority that argues that the voluntary and informed act of an adult negates causal connection. What an adult of sound mind does is not in the law treated as having been caused by another. The Association has also stated, and again I quote, this legislation holds another individual responsible for the choice and act of self-administration of the second person in circumstances where there is knowledge of exposure of the other person to a significant risk of death should the second person take the drug, unquote. The Association also argues this, and I quote further, a second reason for opposing the introduction of this new provision is that it may catch friends/acquaintances of the deceased who are involved in the drug supply and have absolutely no idea of the risk with the particular drugs involved, brackets where there may have been some kind of contamination, comma, an unusual concentration of drugs or an unexpected allergic reaction, bracket. Notwithstanding a general awareness that there is a sufficient risk of death as a result of the self-administration of the drug. Those persons may also have no idea of whether the person to whom the drug is supplied has already ingested other substances or later consumed some further substances which may be the substantial reason for death by virtue of a lethal combination. In some cases, it may be the combination of ingestion of alcohol with the drug use that makes for a lethal combination, where the drug itself may otherwise be dangerous but not lethal. Those persons may also have no idea whether the person to whom the drug is supplied has already ingested other substances or later consumes further substances which may be the substantial cause for death by virtue of a lethal combination. In some cases, it may be the combination of ingestion of alcohol with the drug use that makes for a lethal combination, where the drug itself may otherwise be dangerous but not lethal. So we do seek the government's response to these issues. Schedule 2.2 makes amendments to the concealment offences of Section 316 and Section 316 A of the Crimes Act. As the opposition has noted in previous debates, historically there has been a controversy over a concealment offence. For example, in a 1999 report, the Law Reform Commission argued to abolish Section 3161 with a dissenting minority view. Self-evidently, the government did not accept that view. Some submissions to the inquiry argued that the moral duty to actively assist the police in their investigations should not be extended to a legal one. In June of this year, the Parliament debated the Criminal Legislation Amendment Child Sexual Abuse Bill, which introduced a new concealment offence in Section 316 A. That new provision was aimed at the concealment of child abuse offences and was not restricted to serious indictable offences, as was Section 316. The level of knowledge required of the offenders was lesser, extending not just to knowing or believing, as in Section 316, but also to reasonably ought to know, an objective test rather than the higher bar in Section 316. This reflects the heinous nature of offences concealed under Section 316 A. The amendments in this bill rewrite 316 so that its structure more closely mirrors the more recent 316 A. Importantly, the amendment does not alter the knowledge element of 316 and does not extend to the objective test in 316 A. A graduated penalty regime is instituted for both provisions, for both types of offences under these sections, that is, concealment and concealment for benefit. The current maximum penalties for these offences are respectively 2 and 5 years imprisonment. The sliding scale makes for a greater maximum sentence if the offence being concealed is more serious. The maximum penalty under 3161 remains at 2 years if the maximum penalty for the concealed indictable offence is not more than 10 years. It is 3 years if the maximum penalty for the concealed offence is more than 10 years but not more than 20 years, and a 5-year maximum if the penalty for the concealed offence is more than 20 years. Similar but larger scales apply to 316 subsection 2 offences. For Section 316 A, the scale is simpler. The current penalty remains in place for concealing a child abuse offence with a maximum penalty of less than 5 years imprisonment, with a penalty of 5 years imprisonment where the concealed offence has a maximum penalty of 5 years imprisonment or more. There are similar changes to the benefit offence in 316 A. The increased penalties are not retrospective, which of course is entirely appropriate in the law, Mr. Deputy President. Item 3 of Schedule 2.2 makes what seems sensible changes by adding 316 A to G to provide a member of staff of a school with an alternative method of reporting comparatively minor assaults at school. Schedule 2.3 increases the maximum penalty under 203E1 of the Crimes Act to 21 years from 14 years. This is the offence of intentionally causing a fire and being reckless as to its spread to vegetation on public land or land belonging to another person. Item 2 of Schedule 2.3 adds items to Schedule 1 A to the Crimes Act. This schedule is entitled Former Sexual Offences, quote unquote. Schedule 3 amends the Crimes Appeal and Review Act, which allows the release of information concerning mercy petitions, particularly petitions requesting the exercise of the prerogative of mercy. There are a reasonable number of petitions that are considered for mercy. It is a power that rests with the Governor, although in practical terms applications are considered by the Executive Council, with the real work and consideration being done by the Department. In September of last year, the Shadow Attorney asked the Attorney on notice how many occasions since April 2011 had the Governor exercised the royal prerogative of mercy, and the reply was that between 1 April 2011 and 19 September 2017, the royal prerogative of mercy was exercised in relation to 123 applicants. There was further advice that during the period the department had received 434 applications. In practical terms, it is very difficult to receive a pardon, and given the total number of criminal proceedings, 123 over 6 years is a comparatively small number. There are undoubtedly cases where it is entirely appropriate for a pardon to be issued. However, as the shadow attorney has said publicly, there seems to be something wrong about the lack of transparency surrounding the exercise of the prerogative. The vast majority of convictions and penalties are handed down in open court, so logically a comparable amount of public scrutiny should be available related to pardons. Following an article by Ms Fife Yeomans, the Attorney-General announced a review. Submissions to the Department of Justice were called for with a closing date in February. Given that nothing has then happened for some period of time, the Shadow Attorney placed a question on notice on 16 October seeking advice as to what progress had been made, and then of course the bill was introduced into the House. Schedule 1 to the bill provides amendments to the Children Detention Centres Act and Regulation, the Crimes Administration of Sentences Act, the Crimes High Risk Offenders Act, the Criminal Procedure Act, Surveillance Devices Amendment Statutory Review Act, an act dealt with fairly recently in the Parliament, and the Terrorism High Risk Offenders Act and Regulation. The Attorney noted in his second reading speech that the amendments in Schedule 1 facilitate the implementation of the Terrorism High Risk Offenders Act made last year. There are a number of technical and clarifying provisions and at least 2 more substantive changes proposed. New section 17(1) allows for application of the issue of a surveillance device in a correctional centre. This relates to the possibility of a continuing detention order or an extended supervision order against someone within the Terrorism High Risk Offenders Act. This is an expansion of the current categories for which surveillance devices can be sought, Mr Deputy President. The second substantive change relates to the imposition of a standard form of conditions and obligations upon those subject to an extended supervision order. With these observations, the opposition does not oppose the legislation.
Mr Deputy President.